All right, if you already have a trust, if you have a revocable living trust, a family wealth trust, an irrevocable trust, a living trust, some version of a trust, do you also need a will? Do you also need a last will and testament? And the answer is definitively yeah, you should have both. Here's the reason. One of the main reasons that you do a trust to begin with is to avoid the process after you pass away called probate, right? So probate happens after a person dies. They had a house, they had bank accounts, they had something that was only in their name. And now their next of kin, their spouse, their kids, their charity, church, whoever, has to go to court so that at the end of the probate process, the judge can say, okay, now spouse, you get your husband's house, or whatever the case may be. If you have a trust, and if it was funded, which is a really huge component where I see a lot of people mess up. And when I mean funded, what I mean is you actually have to put the assets into the trust. So for a house, for example, let's say that you've got the John Smith Family Trust, and your house is owned by John Smith, a single man. Well, if John dies, even though he's got the John Smith Family Trust, if he doesn't actually transfer his house into the trust, his family's going to have to go through probate. So the way to fund the trust is he would do a deed to transfer the property from himself. So now the John Smith house is now owned by the John Smith Family Trust, right? So you got to put the assets, the house, the bank accounts, whatever it is, you have to put them into the trust, right? Or if you have a brokerage account at Morgan Stanley, you would put your trust as the beneficiary, right? So if you have a trust, ultimately you just got to make sure that your assets are now into the trust. And if that is done, and it's done correctly, when the person passes away, his next of kin or whoever he's left or she's left her stuff to, they'll avoid probate. They won't have to go to court. They won't have to do anything. It should be relatively simple. So that's if you have the trust. If you have a will and you didn't have a trust, one of the huge misconceptions, and I'm speaking primarily to Florida and to Tennessee, where I'm licensed, but I think this applies almost across the board. If you don't have a trust and you have a will, so in that example, John Smith has his house, right? And it's in the name of John Smith. Well, when John dies, even if he has a will that says he wants to leave everything to his friend Carlos, well, Carlos is going to have to hire an attorney, go to probate, give the will to the judge. The judge's going to look at it, say that it's valid, hopefully, and then eventually transfer the house to Carlos. So you got to make sure, so if you just have a will, you're probably going to have to go through probate. So again, the reason most of our clients are doing trusts is because they want their family to avoid having to go through probate. So if you did that, why would you do the will? Well, common example that I use is, let's say that you have your trust and everything's done perfectly. You've funded it, the bank accounts, the brokerage accounts, the retirement accounts, the house, everything. But let's say that you go buy a cabin in North Carolina, and for whatever reason, you forget that you have a trust and you just buy it in your name individually. You just buy it in your name. Well, you pass away, all of your assets are going to avoid probate except for that one house or that cabin that's in North Carolina. So you would want to have a will in place. And in this case, actually what we would call it is a pour-over will, P-O-U-R, a pour-over will, so that now your next of kin will go to court, or whoever you've named in the will is going to go to court. And the pour-over will, all it basically says is, I want my heirs, my beneficiary, I want them to do whatever my trust says. So the trust might say that you want all of your real estate properties to get sold and the asset and the money split, 50-50 between your kids or whatever. So now the will comes into play for that example, and it just says, do whatever my trust says. So again, you kind of have if you have a trust, you do a will as sort of just a precaution, just as a safety, just as in case for whatever reason, maybe you sign your trust documents after, and you leave your attorney's office, but you get in an accident and pass away. Horrible example. But something happens to you before you get to fund the trust. Well, at least you'd have a will your kids would still have to go through beneficiary or whoever you leave things to, but the will is going to still bring the trust into play so that all the terms, everything that you wanted to happen still happens via the trust. So long-winded answer to the question of if you have a trust, should you still have a will? Answer is 100% yes.